Hi everyone, this is April Sage from Online Tech. Thanks for joining us today. Today I'm very happy to introduce Tatiana Melnik, who is joining us today to share her expertise in the legal implications of HIPAA, HITECH, and business associate agreements. Tatiana, welcome.
Thank you. Thank you so much for having me. Pleasure to be here.
So we've had a fantastic response to this topic. We know that a lot of people are really concerned. We also know that there is an awful lot of confusion about this topic. Can you just set the framework for me and tell us a little bit about what is HIPAA, what's HITECH, make some sense of this alphabet soup and tell us how we got to this, to where we are today.
Sure. So let me give just a brief background. Let me just give you a brief background of HIPAA. HIPAA stands for the Health Insurance Portability and Accountability Act. It was passed in 1996, and it was passed to protect patients, to protect their health information, to protect their treatment information, and anything related to their medical records. Anybody who has ever been to the doctor obviously shares information with their doctor that they would consider private, and they would not want to be revealed or disclosed should something happen. Well, HIPAA was passed to put in certain requirements to protect this information. There is a definition for protected health information, which you see on the screen, and it basically means anything that is medically related, broadly speaking. There are certain exceptions for education records and for employer-related information and employee-related documents, but for the most part, it covers all medical records. And part of HIPAA includes the specific standards for privacy and security. HIPAA applies to covered entities.
And what's a covered entity, Tatiana?
A covered entity is, broadly speaking, a health plan, a healthcare clearinghouse, and for most companies, it's anybody who transmits healthcare information. So that definition encompasses just about everybody who touches healthcare-related information, even Google or Gmail, even though they are excluded under certain exceptions.
So this might, obviously it would include a doctor's office or a hospital, but it could also include anyone that writes software for the health IT industry.
Absolutely.
Or anyone that's involved in maybe record storage or record disposal or record backup, whether it's hard copy or digital copy?
Absolutely. The key point with figuring out whether or not you are subject to HIPAA and HITECH is whether or not you have access to and maintain medical records or medical-related data. So, for example, if you're a software developer and you develop personal health record software where you process and do some sort of processing with people's medical records, you're covered. You're required to either be a BAA or a covered entity. And so you are subject to the requirements of HIPAA and HITECH. And before we briefly move on, I'd just like to give a brief overview of HITECH because that's really the big deal now. HITECH was passed in 2009, and it was passed in large part due to the government's effort to modernize the healthcare industry. Most companies have already moved to using information technology systems and services to process data faster, to save money, to do all kinds of great things, except for the healthcare industry. And they are just slow to move on. For whatever reason, they're slow to adopt technology. And so the government was trying to help them out. Well, a big concern with adopting technology is the release of people's medical records. Everybody's terrified that all of their data is going to end up on the internet. Well, I don't want my medical record on the internet. I'm sure you don't either. So part of this was to protect patients because Congress believed that ONC and the Department of Health and Human Services specifically was not enforcing HIPAA the way it should be. They weren't really fining people for violations. They weren't really doing the investigations that had to be done. And in an effort to alleviate consumers' concern about their medical records being in electronic form, they put in very stringent breach notification requirements.
And so what's been the result of the HITECH Act? And I know that we've been seeing a lot of news about data breaches involving health-related information and news about a lot of fines. So it seems like HITECH was really a game changer in terms of responsibility and what it could actually translate into as far as accountability.
Absolutely, absolutely. That's a really great assessment of the implications of HITECH. I wanted to bring up the slide you see now because in that last sentence, you'll see that as of September 26, 2011, 330 reports have been filed with ONC. Part of HITECH is a mandatory notification to the Secretary of Health and Human Services if a breach affects more than 500 individual records. You'll see that more than 11 million records have been affected, and these reports are just since the passage and the implementation of this breach provision, which is probably about a year at this point, maybe a year and a half. So you can imagine what was happening before this came into play, right? So as a result of a lot of these notices, you've had several attorneys general institute actions against companies. Under HITECH, attorneys general, state attorneys general, not just the secretary, has the power to sue companies and to get monetary compensation for the victims of their state. We've seen this in California, I'm sorry, not in California, in Connecticut, in Massachusetts, and several other states. And we expect that as times get tougher and states are looking for more money, it's just going to be more reason to go after these companies where these breaches occur.
So it's no wonder that people are extra worried about security and their own responsibility. And we see that across the industry, whether it's a doctor's office or whether it's a service provider, everyone really wants to understand how they are liable.
Yes, absolutely. And it's because they are, the minute you require a disclosure, right, that something bad happened, everybody comes out of the woodwork. You do have certain liabilities as a covered entity and as a business associate. As a business associate, you have to report breaches to the covered entity. And as the covered entity, then it's your obligation to investigate and notify the secretary if necessary. The biggest issue under HITECH isn't necessarily the fact that you as an entity have to report to the secretary because, you go online, you fill out a piece of paper, and you're done. It's the fact that now you may have to notify all of the individuals that were affected, right? You have to send notices. You have to go through and comply with the notice requirements, the breach notification requirements for your particular state, and for the states where the individuals whose information was breached live. So that could be 30, 40 states, and each state has their own notification requirements. Then if the secretary does decide, hey, you did do something wrong, and they come in and investigate, now you have to comply with all of that. And those are very expensive undertakings. So it's not necessarily that you have to be concerned that someone will sue you. It's pretty much a given. Someone will, right? Because they're upset you violated their rights in one way or another. I mean, a lot of people won't, but someone likely will, unfortunately. But it's the fact that now you have all of these extra reporting notification requirements that you wouldn't have. And if the secretary does come in and say, hey, you did something wrong, we need to evaluate this, more likely than not, their standard practice is to require that you comply and you be audited and report to them for an additional 3 years.
Wow.
So those are additional obligations that now you have to undertake.
So we're talking about huge expense in terms of time,
right,
energy, and obviously money.
Right.
So I know you touched on some examples of companies who are subject to HIPAA and HITECH. And just to revisit that for a moment, maybe it's easier to understand by asking the opposite question. Is there anyone who's not responsible for HIPAA, for protected health information, if they come into contact with it?
There are. So and a lot of this is going to be focused on the breach notification requirements because obviously if you get healthcare information, you usually work for the company, right? You're in a hospital, you're a nurse, and even under those circumstances, there are breach circumstances, right? If you, as a nurse, access the medical record of an individual who is not your patient, right? If Britney Spears comes into my hospital and I want to see why she came into the hospital, if I access her medical record and yet I don't treat her, I'm not on her treatment team, that's a breach and that's a violation. And people do and have gotten fired for that. So just keep in mind if there are any nurses out there, don't be too curious. But more directly to your question, who's not subject? Organizations who do not actually process the data are not subject. However, in light of the concerns about breach notification requirements, organizations who trust other entities, other businesses to store their data, to process their data in certain ways, to do other things with their data where they're not necessarily accessing protected health information, will request a business associate agreement because they are so terrified that something will happen and they're not going to have proper notice.
So what is a reasonable expectation for a hospital organization or physician's office to expect when they're working with their vendors?
Mm-hmm.
Do all vendors, are they also required to meet HIPAA compliance? Should it just be the norm that a BAA or a business associate agreement is always signed?
It depends, again, what that organization, what that business is doing for you. If it's someone who, for example, if I'm a hospital and I have janitors on my staff, well, they're not going to, they're not in their job description, there is no reason why they should ever have access to protected health information. Nonetheless, I'm going to say, hey, listen, janitors, you guys are in here, you see the patients, right? You know who they are. Yes, you're subject, right? Even though you're not necessarily doing anything with it, by the mere fact that you're present and you see the patients, you have access to protected health information. In general, most organizations are going to ask that a BAA is signed. Whether or not that's the right thing, that's arguable. So an organization like Online Tech, they may or may not actually be a BAA if they process or if they store protected health information, right? But organizations that come here that are healthcare entities are going to ask them to, in fact, sign a BAA because they're going to verge on the side of caution.
Sure. And we've seen a lot of people asking about encryption requirements for either storage or transmittal or processing. Is encryption a requirement of HIPAA or HITECH?
It's not. It's not a requirement. The HIPAA rules are actually quite flexible in how you implement them. They are very specific in the kinds of things you do have to do. For example, you have to do a risk analysis. You have to do all these other things. You have to implement policies and procedures. You have to train your employees. But the means that you use to implement that is really up to the company. And they do that because they recognize that not everybody is a multi-million-dollar entity, right? Not everybody can put the same resources into training, into encryption, into security, into all these other things. And so they made it so they're flexible so that organizations can choose the things that are best for them. So no, there are no encryption requirements. However, under the breach notification requirements, you as a covered entity or a business associate are automatically subject to those notification requirements if the data is unencrypted. Okay? And the Secretary of Health and Human Services provides guidance for how that data is supposed to be encrypted. So for organizations that want to get an out, so to speak, have to encrypt their data.
Okay. So it sounds like that's probably evolving as a standard best practice.
Absolutely.
And HIPAA and HITECH may not be prescriptive, demanding that a specific type of encryption or a formula for doing it happens. But it sounds like there is a requirement that the process of how the sensitive information is handled is documented and audited.
Right. Well, there is a requirement. So the Secretary of Health and Human Services does actually set forth specific requirements that you have to follow to encrypt the data, and they're NIST standards, the National Institute of something. I forget what it stands for, but it's NIST, and it's on slide, let's see where I have it here, right here, the getting out of breach notification, and there is guidance available. Again, it is to be updated annually. So organizations that do want out of the breach requirements, breach notification requirements, have to encrypt following these standards.
Okay.
Okay. Obviously, however, not all data can be encrypted. Paper records, right? They can't be encrypted. So if you lose a huge percentage of your paper records because someone decides to come in and steal, you know, whatever bin you have them in, that's a breach, and you can't. The only way to protect against that is to lock your doors, right? There's nothing you can do electronically really to protect against that besides not having those records in the first place.
Okay. So let's go back to understanding some of the implications and risks, both personally and professionally, of exposing protected health information. You mentioned that even a cleaning service might be subject and responsible for that type of data exposure. And aside from the cost of doing business, if everyone is requiring a BAA to be signed, what are the risks in terms of fines or personal and professional liability?
Well, initially, you do have obviously the cost of actually entering into the transaction, right? So you need to negotiate the BAA. There's always going to be entities that say, we're not subject to this, we're not going to sign this. And my recommendation is that if you believe they are subject to it and they refuse to sign it, do yourself a favor and don't do business with them. Because in the end, your agreement is what protects you, right? You go and you look at the indemnity provision, the risk provisions in there, and you find out who's paying for what. That's the point of having that agreement in place. Aside from just the actual contracting costs, if there's a breach, right, you have to notify the individuals. So now you have your population angry at you because you're supposed to be providing secure stuff and you're not, right? So now you have a whole issue with trust. If you have to notify the media, because if there's over, I believe, 250,000 records affected, then you have to do basically a press campaign to make sure that everybody gets noticed. Well, one, that's expensive,
Sure,
right? Running TV commercials, pretty expensive. And it doesn't make you look good. I mean, it's really difficult to fix your image once something like that happens. And unfortunately, there's been several cases in that list that I showed you where the same entity has had multiple breaches within a year, right? Like 3 months apart, they lost a laptop, they had a server stolen, and things like that, right? And so now you have to go back and keep saying, hey, we're having all these breaches. Well, again, very difficult to fix your image. Also, depending on what happened, if it was the fault of a doctor, if it was the fault of a nurse, they can get reported to the licensing board, depending on what happened. I mean, there have been instances where doctors and nurses have been reported. There was one particular in Minnesota where nurses took pictures of a patient and put them on their social media website. They put them on Facebook. And they got reported to the state licensing agency because obviously that's a violation of someone's privacy, right? That's a HIPAA violation. And it's just not nice to do.
No,
right?
no.
That's not very nice.
It's not going to give anyone warm fuzzies about going for confidential treatment.
In terms of actual penalties, they can get pretty high. So they can get pretty high. It's really important that you as a business owner are educated about your obligations under HIPAA because, for example, if you are and you don't train your staff, it's very easy to say that that's willful neglect, right? Willful neglect gets you into a minimum penalty of $10,000, a maximum penalty of $250,000. I'd like to know the last time the government gave a penalty of $10,000, right? So you're not going to be paying that minimum amount. You're going to be paying probably closer to the maximum because that's how you learn your lesson.
So willful neglect means that the company was aware that there was some issue and hadn't done their due diligence to address it.
Yeah, that's right. That's right. And in this time, I mean, it's very difficult to say, you know, that you couldn't have known, right? With the media attention on HIPAA and HITECH and healthcare in general, it's difficult to argue that you couldn't, as a business owner, you did not know that you were subject to these obligations.
And it seems like someone who's interested in minimizing their liabilities is going to follow through the processes of due diligence on a business associates agreement and on data encryption just to limit their liability should something go wrong.
Absolutely, and that really is your best protection, is to follow the rules, right? If you have a policy in place, if you can show that you train your employees on a regular basis, right, there's particular requirements for training. You do, when they first come in, you do periodic 6 months or a year, however your organization decides to do it. And then you have some rogue employee that decides, hey, TMZ would really love that information on Britney Spears, right? I'm going to sell that. Well, you as the hospital or you as the software developer or you as whoever that has this information is not going to be liable to the same extent that an organization that just ignored everything and said we don't really care, right? They're going to come in, they're going to investigate, and they're going to say, oh, wait, this really was a rogue employee. You're doing everything you can, and there's just nothing you can do to protect against employees who do bad things sometimes, right? If you're doing everything you can, that certainly gets recognized.
Okay. And so companies who are involved in health IT are presumably going to do everything they can to encrypt their data and keep things secure and always available, but things might still go wrong. Is there insurance that will protect companies against violations of healthcare data?
There is insurance. At the moment, it's still a little bit on the expensive side because this is a relatively new area. And so insurance companies are still trying to get a grip on how much these kinds of expenses are going to cost. There isn't going to be insurance to cover you for your willful violations, right? If you get a fine from the government, to my knowledge, there's no insurance company that will cover that in light of that being punishment, right? Because if you don't feel the punishment, if you get insurance coverage for it, then why would you not do it again, right? Because if it's cheaper for you not to comply,
right,
then you're always going to choose that option. You're just going to pay your premium for your insurance policy. I would like to note that I know a lot of this stuff seems really, really scary, and it's not. You have plenty of healthcare organizations and organizations that deal with protected health information. They're out there that are doing business. They aren't having a problem, right? All you have to do is comply. And there are plenty of attorneys, there are plenty of consultants who provide services that will help you get to a point where you're complying. The onus on you then is to make sure that you follow through, that if you have policies and procedures in place, that you actually follow those policies and procedures. Right? If your policies say that here's the 1, 2, 3 step, or if someone does something bad, then you need to follow that and make sure that the policies and procedures you have are actually, in fact, reflective of what you do. The worst thing you can have is have policies that do not reflect what you actually do in your business. It really is, because that is the true definition of willful neglect, is that you have a policy, you know it's there, you were smart enough to put it in place, and then you just ignored it.
And it sounds like you also have a responsibility to communicate these policies to everyone.
Absolutely.
If everyone is liable for it, then the onus is on the company to make sure everyone's well informed.
Absolutely. Absolutely. It is very, very important that employees are trained. And most importantly, when they're done with their training, they sign a certificate that says, yes, I went through the training. Yes, I understand HIPAA. I understand my obligations under HITECH. I understand all this stuff, because that is your protection, right? If someone comes in and says, wait, you didn't teach me this stuff. You have the certificate that says, wait, you took these classes. I can't force you to pay attention. I can't force you to do this, but you did say you took these, and so you are individually responsible.
Everyone's sharing accountability.
That's
all
right.
Across the board.
That's right.
So what are the 3 most important things that a company should do to meet the obligations under HIPAA and HITECH? What do you recommend?
1, know your requirements, right? Know whether or not you're subject to it, and know the level and extent to which you're subject to it. Not every organization has to do the same stuff. For example, if you don't keep paper records, you don't need to worry about that, right? If you don't keep electronic records, you don't need to worry about that. So know what you're supposed to do. 2, have policies and procedures in place, right? Policies and procedures and training. And 3, make sure you have those agreements in place. I cannot overemphasize, I always see people going into these relationships without having contracts in place. A contract really is your best friend. It doesn't have to be complicated or spell out every single detail, but you do need to spell out, hey, you as a business associate or a subcontractor or whatever your role is, you have to tell me within this number of days that there was a breach, okay? And then I take the responsibility to investigate, right? You need to set out those parameters, because if you don't and you find out later that there was a problem, it looks much worse.
Well, with the stakes as high as they are, sounds like you want to do everything in your power to get the communication early, make sure everyone's on the same page and has the same philosophy about, you know, protecting sensitive data.
Absolutely, absolutely. Again, training, training, training. And keep in mind that the Department of Health and Human Services is not in there, it's not out to put you out of business. Yes, these requirements are a little onerous, right? But put yourself in your patient's shoes or whoever's information you're storing. Would you want your information released? You'd want to know that the company that's housing your stuff is doing what they can to protect it, and to be sensitive to the fact that, you know, you're processing, you know, transmitting people's private stuff, like the privatest stuff that they can have. It's like their diary, basically. And you don't want that released. And so, you know, just the golden rule.
Sure. Now, what are the 3 things that a company should never do and make sure that they avoid at all costs?
Obviously, committing breaches, number 1. Right? That's the easiest. And then that's also the hardest to do. And, you know, I understand that in the age of digital technology, it's just unavoidable that you're going to have a breach. It's unfortunate, but it's just really unavoidable. The important thing is that you have a plan in place, right? So you just have to make sure. Some things that you should never do. 1, do not ever write policies and procedures that do not actually reflect what you do, okay? If you currently have policies and procedures in place that were adopted from, you know, taken from Beaumont's website or whoever, and you just said, oh, this looks really good, you know, that's bad. I mean, that's step number 1, because, again, that is the true definition of being willfully negligent. 2, if the Department of Health and Human Services calls you or anybody from that area, please answer the phone. Do not ignore their calls. They are not going away. And the reason I bring this up is because not too long ago, there was a company who actually did that, and they were the first company to receive an actual fine. And their fine was, I think it was $1.3 million for the actual violation,
wow,
and then $3 million for ignoring HHS.
Wow.
So take that as a lesson. Don't ignore. Call your attorney, respond, and just do the best you can. Again, they're not trying to put you out of business. They're pretty reasonable people. You just got to answer the phone.
So it sounds like playing duck and cover is not a good idea. You want to be transparent. You want to have open communication and show your best effort to resolve any conflict.
Absolutely.
Great. Well, we're going to open this up for a minute to other questions. So if anyone has any other questions they'd like to ask Tatiana, feel free to submit them in your chat box or in your question box. And Tatiana, if you have some contact info to share with us, if you're open to additional questions,
sure,
let us know.
Absolutely.
And if anyone has any questions for us, they can always email contactot@onlinetech.com. We're happy to help you however we can or point you to someone who will be able to. I'm going to take a minute and check and see if we have any questions. All right, well, one of the questions I see here is the most frequently asked question, and the answer is yes. These slides will be made available, and if you stop back to our website, you'll be able to see a recording of this webinar. We will email all attendees a link, so check back in a couple days and we'll email you proactively and let you know when you can come back and revisit this webinar. Another question is, are insurance agents and brokers covered?
It depends on the kind of insurance they're providing. If they're providing auto insurance, probably not, depending on what you're getting with that policy. If it's healthcare insurance, absolutely.
Okay.
Absolutely.
And Lee Vance, you had a question. What company is this? So we are Online Tech, and we are a data center operator, and Tatiana is an attorney with Dickinson Wright. Another question, is there a good resource for free templates of policies and procedures? No, but if you send me an email, I will email you some links for some places that do provide their policies and procedures that you can use as a model. Again, please make sure that whatever you adopt, you read and double check that it actually conforms to what you do. So it kind of gets back to that, making sure that any policy or procedure you have in place is directly relevant to your company and what happens in your company. So
absolutely,
the best you could hope for is a good starting place,
right.
But everyone's going to have to modify and be specific.
Absolutely, and I know those models are actually very helpful because a lot of times you really don't know what to say, you don't know how to word stuff, and you know there are plenty of policies available at university websites. I know, for example, Yale and the University of California do post their information online, and it is available. And again, if you email me, I'll be happy to send you those links.
Great, thank you. What's a reasonable amount to expect to pay for a risk assessment or HIPAA audit?
It's hard for me to gauge that because it really depends on who you're hiring. There are many consultants who provide these services, and they will generally charge anywhere between $500 for the mere basic to $5,000, $10,000 if you want the in-house training, if you want all the policies and procedures drafted for you, if you need all those additional services. A lot of attorneys also provide those services, so then it depends on what plan they have available, because a lot of law firms will have, you know, a package deal available for services like that. Okay. But it can't, I mean, it can be costly.
Sounds like you need to kind of check around.
You do. You really should. You absolutely should contact numerous organizations and see what they're charging, because this market right now is very, very competitive, and so you can definitely find a good deal.
So check around, get some quotes.
Absolutely.
Okay, great advice. Thanks. Who should be responsible in a healthcare organization for monitoring HIPAA? Should it be primarily those involved in compliance or HR, legal, IT? Is it everybody?
So there's actually a requirement under HIPAA that each organization have a privacy officer.
Okay.
That is the person that's supposed to be in charge of monitoring these types of things. For example, if you have if you are an organization subject to HIPAA and you actually have, you see patients, you're supposed to provide them a notice of privacy practices. And in that, you're supposed to disclose your privacy officer. It's best for each organization to appoint one individual to monitor these types of developments, because if you have multiple people, it gets confusing. If you don't have anybody, again, it gets confusing.
Sure. Well, I wonder how many people are raising their hands. So next title. Let's see. We've got great questions coming up here. Thanks, everyone. Keep them coming. Are there any special responsibilities I need to be aware of as a technical writer for a healthcare organization?
As a technical writer, you probably don't have access to protected health information, right? If you do, then you're under the same obligations as anybody else who has access to protected health information. If you're in a hospital, for example, right, again, you're subject to the same stuff. But to the extent you don't actually have access to PHI and you're not doing with anything with PHI related, then you don't really have any obligations.
Okay. Does HIPAA or HITECH affect financial institutions at all?
Financial institutions have their own requirements. They actually are subject to the Gramm-Leach-Bliley Act, amongst a whole other multitude of stuff. If you think healthcare is regulated, wow.
Whole new can of worms.
It's a whole new can of worms in the financial services sector. They are generally not, because they have their own regulations. They actually, the breach notification requirements were actually modeled after the breach notification requirements under Gramm-Leach-Bliley and some of the other implementing regulations.
So those institutions actually might have a head start as far as meeting HIPAA compliance.
They absolutely do.
Okay. Hopefully that'll be reassuring. What's the best way to handle PHI in email?
Don't do it. Email is not a secure form of communication. Unless you're sending encrypted email, you should absolutely not do it.
All right, good clear answer on that one. 2 more questions here. Recently, Rite Aid drugstores was fined over $1 million for throwing away pill bottles and records without shredding.
Yes.
The patient data fell into the wrong hands.
Yes.
What methods do medical field clients need to take to protect digital data and associated paperwork? For example, hard drives, USBs, and printouts.
Take a look at the NIST standards. There's actual requirements for what you're supposed to do in best practices, and those are the ones that are outlined by the Secretary and approved by the Secretary. Those are the ones you should look to. And let me pull up that slide again so you can see it. And you'll see there's specific regulations for data at rest, or specific publications for data at rest, data in motion, and electronic media.
Great, thanks. Last question we have for you here. Can you comment on the importance of 2-factor authentication for accessing web-based applications that contain PHI?
My first thought would be to make sure it complies with the NIST requirements. And I believe that 2-factor authentication does, in fact, comply with that. The other issue I have is, where is that other data stored? Where are you going to access that data? Because a lot of times you'll have situations where you have all these protections at the front end, but then you're using shared hosting, where, for example, there is no barrier between your account and whoever else's account, or you don't have good barriers between those in those sections of services. So that would comply. My initial reaction is that kind of framework is actually really good. On the other hand, you want to be careful that everything else you have, that's not the only thing you're depending on to secure that data.
Great. I had one more sneak in that is near and dear to online tech. I had a question about data centers. Software vendors outsourcing their data to a data center, are both the vendors and the data center operator responsible for protecting that data? And do each of them need separate policies and procedures?
If they're handling data for healthcare clients, I'm assuming you mean separate policies and procedures in those different roles. Yes, generally you would have different policies and procedures for those roles. A lot of that stuff will overlap, but to the extent that you have different obligations under different roles, you should have different policies and procedures.
So everyone needs their own specific set of policies that speak to their business processes.
Right. So if in that situation, if you mean one organization is playing 2 roles, yes, you should have different policies and procedures for the different roles. If you mean two different organizations, the one that's outsourcing and the one that's receiving the data, yes, absolutely, they should have policies and procedures in place. And again, I would like to note that it's not clear that organizations such as online tech are actually subject to the requirements of HIPAA. Microsoft, for example, has taken the position that they're not subject for their personal health record system, that they're not subject to HIPAA. However, recognizing that people are concerned and will not use their service, they actually do sign a BAA.
Interesting. Well, thank you so much, Tatiana. We have learned an awful lot and appreciate all your time and answering these great questions for us.
Well, thank you so much for having me, and thank you everybody for attending.
Thanks, everyone. Hope to see you on another webinar soon. Have a great day.
Bye.